true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine versus Rogelio Valero Jr. Can I have parties announced for the record for the state?
Jason Gary, Your Honor.
Defense?
Will Brooks, Judge.
Are you Mr. Valero?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rogelio Valero Jr. who was placed on deferred adjudication and cause number 2024 CR 1726 for the offense of possession of a controlled substance, penalty group 1, 4,200 grams on June 6, 2024 for a period of 5 years? Is that you?
Yes.
All right, state.
Yes, Your Honor. Following condition number 1, on or about the 29th day of October 2024, Fair County, Texas, Defendant Rio Valero Jr. Convicted of possession of controlled substance, penalty group 1, in violation of condition.
How do you plead to that? True or not true?
True.
Any objections?
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
It's under me, Your Honor.
All right, state, what are you requesting?
The state is requesting revocation, Your Honor, and since the individual did plead true to the number 1, the state would be taking into consideration that case. Supervision is called number 2024 PF 21614.
And with regards to the case that's being taken in consideration, do you have an amount?
It was from 1 to 4. That's what it's charged as. We haven't got the hours back yet, so it quite possibly could go below 1.
All right, and defense, what are you requesting?
Judge, I'm asking the court to order Valero into treatment, and I can give the court an explanation as to why.
Yes.
So Mr. Valero started using methamphetamine in 2020, Judge, when he lost his mother. The drug has taken a lot from him, taken his family from him, taken work, friends. He has continued to use, Judge, up until he was incarcerated for this particular offense, both by admission and by positive test. He is an addict, Your Honor, and he is appearing for you in front of you today, asking you for some help. He's ready to make a change in his life. Unlike many clients that I have, Your Honor, who tell me, no, I don't want, they want the Burger King. They want treatment and they want it their way. He was very forthright about the fact that he needs and wants some help. He has not ever been to inpatient treatment, Judge. He's 51 years old. This is the most significant trouble this gentleman has ever been in. There was an updated TAP evaluation, which actually, I'm sorry, there was a TAP performed, which is the first time it had been done, even though it had been ordered while he's been in jail. And that TAP recommended that he be sent to the substance abuse treatment facility if the court should consider that modality of treatment. And I invite the court to talk to Mr. Valero if the court has questions, but I found him to be pretty earnest and honest about his usage. There was no excuses, nothing offered to try and shade it his way, if that makes sense.
All right. Mr.
If I may too, I'm so sorry. Last thing,
Yeah.
this is the longest that he has been sober since that period of time. He's been in since October, but that's his longest period of not using methamphetamine. He started that usage in
All right,
2020.
this is what the court is going to do. And the court realizes that sometimes there's a big difference between possession with intent to deliver and possession. Now, if you would have had a chance to use the drugs, then you would not have been charged with possession. And based upon what the state has told me about what they anticipate the level of felony may be and the amount of drugs, it appears to the court that there is a drug issue with you and not an issue of your being on probation and selling drugs. So this is what the court will do. I'll deny the motion. Take in consideration 2024 PF 21614, alternate amend conditions to include inpatient treatment, follow the TEP recommendations. And also, I know that felony drug court said no more referrals until, when is it, Mr. Brooks?
Well, we're down a case manager right now, Miss McKenzie, and so she's on maternity leave, which started 3 weeks ago or so.
What we'll do then, Ms. Abrams, after inpatient treatment, do a referral to felony drug court. There is to be partial GPS, waive the fees, and that partial GPS is to be upon release from inpatient treatment. And he's allowed to have employment and of course, go to treatment appointments. Probation, is there anything else?
No, man.
Is there anything else you need from the court to continue being sober?
I appreciate your help, and I'm sorry for all I have done wrong. And thank you very much.
All right, you're welcome. We can go off the record in this court to be successful in probation. Communication is key. You can't do this thing where you go on a bender and then you don't report. If you think you're going to use, then you need to make sure that you have a sponsor or someone you can call. You understand?
Yes, ma'am.
All right, and also, Ms. Abrams, we'll add 90 sober meetings in 90 days upon release. All right, thank you. And did IT leave or there?
Yes, they need to disconnect the server to get it.
Okay. Rams, range of punishment is 10 years to 99 years or life in prison and up to $10,000 fine. All right, we're gonna go on the record. Court is calling 2024 CR 010059 State versus Jesse Mareno. Can I have parties announced? State?
Jason, do you have to say?
Kurt Bartolome on behalf of Mr. Moreno. Mr. Moreno on bond, present, ready for plea, Judge.
All right, and you're Mr. Mareno?
ma'am.
All right, you need to make sure you speak up.
Sorry.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mareno, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
But the lesser included just possession of over 400 to make it up to 99.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
I did, Your Honor.
Did you understand it and sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 over 400 grams. Range of punishment is 10 years to 99 years or life in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you intend to
no.
give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
As to both, yes, Your Honor.
Mr. Moreno, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense, recommendation of deferred adjudication. They're taking in consideration AL 2150458. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
There have been none at this time heard or ruled on, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation and drug offender education program and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, the lesser included offenses charged, how do you plea?
No contest.
State any evidence.
You've reviewed the documents and the drug test, Judge. No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
All right, and there's a reason for this offer, I'm assuming?
Judge, I didn't. I thought-
All right. So why should I follow this?
Well, first of all, Your Honor, my client obviously has made a serious mistake, Judge, and he's very contrite. I've known,
Choice.
well, Judge,
Not a mistake, choices.
amen, Judge. I'll use the word choice.
All right, thank you.
A poor choice, Judge, if I may qualify that. Secondly, and more importantly, Your Honor, I've counseled with him long and hard. I've known his family for a number of years. He has support, Your Honor, of his family. He understands the risk. He understands the significance of a 99 to life possibility, Judge. And he understands the responsibilities that are necessary to demonstrate to this court that he can and will become a productive citizen, Judge. I would ask the court to follow the 6 years deferred. He has employment and he is capable, Your Honor, and I can assure you, he is exceptionally nervous, Judge, at this point in time. But I believe with his family, and we visited long and hard about this on at least 3 occasions for over an hour, Judge, I would ask that the court follow the agreement, place him on deferred for 6 years, Your Honor, with conditions the court would deem appropriate. And with that, Your Honor, I defer to the court.
All right, what do you do for a living?
I do construction concrete.
And how old are you?
I'm 24.
Do you have any children?
I'm not.
All right, this is what the court is going to do. Court is going to sentence you to 10 years deferred adjudication, 90 days in the Bexar County Jail as a condition of probation. That's to start today. TAP evaluation to take place in custody. Follow TAP recommendations, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or minors. There's to be GPS upon release, waive fees, and it will be partial GPS for employment only. 200 hours of community service restitution. Take in consideration AL 21505. I'm sorry, AL 2150458. Probation, and I'm going to want field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else that you need from the court to be successful?
Can you speak up and say something?
No.
Can I talk to him though, Judge, before you take him in the back?
Just 1 second. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Did you review that with your attorney? Did you understand it and sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
May I speak to him before they take him back?
You can speak to him that way because we have juries.
I thought that, Judge. I just wanted to be safe.
Just 1 second. Excuse me, who are you? All right, and who is this? All right, so let me just tell you something. Do you know how many people die every day because somebody is selling drugs to them? A lot. He could be going to prison for 10 years. He is not. He is going to the Bexar County Jail. He's been given probation. Other people who have used drugs that maybe he sold to them or that somebody else sold to them, you know where they are? They're dead because somebody is preying upon their weakness and somebody has gotten them addicted to drugs. So if there are tears, there should be tears for the people who have died because somebody sold drugs to him. He's not going to prison. He's at the Bexar County Jail. He will be given probation. So if there are tears, cry for the people who have been found in the field, OD'd, got some bad drugs, for the people who are trying to be clean and sober, but there's some dealer out there who keeps coming up to them and saying, just try it, just only one time, because they are building their happiness off someone else's misery. Yes. All right, thank you.
Say something to you.
No, no. All right, the court is calling 2024 CR 1726, State of Texas.
The case of State of Texas versus Rogelio Valero Jr. begins with a stark reality. Standing before Judge Stephanie Boyd, Valero admits, clearly and without protest, that he violated the terms of his community supervision. Judge Boyd ensures the record is crystal clear. This plea could cost him up to 20 years in prison and a $10,000 fine. Valero acknowledges the risk and still pleads true. The state wastes no time. Prosecutors formally request revocation, signaling that leniency has run out. But the defense counters with a deeply personal explanation. Valero's attorney describes a man spiraling into methamphetamine addiction after the devastating loss of his mother in 2020. This isn't a career criminal, the defense argues. This is an addict asking for help. A TAP evaluation supports the claim, recommending inpatient treatment. Judge Boyd listens carefully. Her response is firm, deliberate, and commanding. She makes it clear that accountability matters, but so does intervention. Then comes the decision that destroys expectations across the courtroom. Instead of granting the motion to adjudicate guilt, Judge Boyd denies revocation. But mercy does not come without consequences. Valero is ordered into inpatient treatment, must follow every TAP recommendation, and will be referred to felony drug court upon release. Strict supervision is imposed, including partial GPS monitoring limited to employment and treatment. On top of that, Judge Boyd orders 90 sober meetings in 90 days, leaving no room for excuses. Her message is unmistakable. Communication and responsibility are non-negotiable. If temptation strikes, Valero is expected to reach out, not relapse. Overcome with emotion, he thanks the court and apologizes for his actions. Judge Stephanie Boyd doesn't ignore violations. She destroys them with structure, discipline, and one final opportunity to change. This wasn't a free pass. It was a last chance.